Hi everybody, it's Simone here. This week's topic is about negotiation and mediation. This lecture is about an example of a type of mediation, which is the mediation used in a legal aid family law setting. In a family law setting, it's a requirement for most parenting matters that prior to commencing court proceedings, the parties participate in mediation or alternate dispute resolution. And they're required to get a certificate to say that they have. Legal aid facilitates mediations in a particular way, and it's something that solicitors, particularly young solicitors, tend to do quite a bit. So I just thought I'd give you an idea of the process. So basically what happens is you have your client, either the mother or the father generally, but sometimes it can be a grandparent or another interested party. And the mediations can happen a couple of ways. So generally each party has a solicitor, although that's not always the case. And it can happen either face-to-face or by telephone or by what we call shuttles. So that means that you might not be in the same room. The mediator might go from room to room, or you might not be on the same telephone call. So the mediator might ring and speak with you and then ring and speak with the other party. So then obviously there's also a mediator who is accredited to do that particular role. So what would generally happen is wherever you are, whether it's by telephone or in person, the mediator would introduce themselves and introduce everybody, and then give each party the opportunity to explain what it is that has been happening, why they've come today, and what they're hoping to achieve. And that gives the parties each a bit of an opportunity to say what their goals are and what their concerns might be. Once each party has done that, the mediator then forms a bit of it, reads back to each of the parties to make sure that they have understood everything that they've heard, and then reads back to them what they've said, and then forms a bit of an agenda out of what things need to be covered through that mediation process. They'll then start some discussions and have some discussions from both parties. With legal aid mediations, the focus is on the clients or the parties doing most of the talking rather than the lawyers. Particularly in the beginning, that's the case. And so there are a few things that can happen. The parties can talk to each other. They might want to have some time out to speak to their solicitors, which can happen. If there's getting to be a bit of a difficulty in moving forward, then the mediator might have private sessions with each of the clients while their lawyers are present. So you and your client, or the other party and their client, and those sessions are confidential unless there's something in those that you say to the mediator, or your client says to the mediator, please take that to the other party as a proposal. As the mediation moves forward, if there is able to be an agreement, then often at that point in time the lawyers start to do more of the talking and nutting out the nuts and bolts and the practicalities of what the agreement is that's proposed. And then usually one of the lawyers would agree, if there is an agreement, that they would be responsible for drawing up the terms and sending them to the other lawyer. And then the agreement's formalised either by way of consent orders or by a parenting plan. So that's just an example of a type of mediation that if you practice in family law, then you will be involved in something like that. And there are different mediations with different people, like community legal centres or like Family Relationships Australia, and other different private organisations as well. There's lots of different places that have mediation and lots of different ways that it can happen. That's just an example of something that happens on a fairly regular basis. Have a good day.